a study of Rule 126 of the Rules of Court, the search and seizure. So, what is a search warrant? That is in section 1. A search warrant is an order in writing issued in the name of the people of the Philippines, signed by a judge and directed to a peace officer, commanding him to search for personal property described therein and bring it before the court. Again, a search warrant is a document. It is an order of the court issued. It's a written document issued in the name of the Philippines, signed by a judge with its signature, and directed to a police officer, commanding him or her to make a search for a personal property, to discover or to get possession of a personal property, and such personal property must be specified or described properly in the search warrant, and bringing the personal property before the court as part of the evidence. Take note that a search warrant is not a criminal action. It is not a commencement. It is not an act, or it is not a document to commence a criminal action. No. But the very purpose of search warrant is only for the discovery and to get possession of the personal property that is under in the World Wide Web Corporation versus People 2014. Take note also that it is the right against unlawful search and seizure is stipulated in the Section 2 of Article 3 of the Constitution, that is our Bill of Rights, wherein the right of the people to be secure or be protected of persons, of houses, papers, and effects against unreasonable searches and seizures for whatever purposes and nature. So again, this search and seizure is correlated to Section 2 of Article 3 of the Constitution, wherein every individual is protected from the unreasonable searches and seizures of whatever nature and whatever for any purposes. And no search warrant or warrant of arrest shall issue except for a probable cause. Again, the search warrant is determined personally by the judge, based, and he found a probable cause that the crime has been committed using such personal property. Again, the search warrant is based from a probable cause to be determined personally by the judge after examination under oath or affirmation of the complainant and the witnesses he may produce. So it must be based, the search warrant or warrant of arrest must be based on a probable cause. And the personal property must be particularly describing and the place to be searched and the person or things to be seized. Again, not just only the personal property to be searched, but also for the person, but also the place to be searched, and also the place to be searched must be specified. Again, the search warrant must not only specify the personal property to be searched or to be seized, but also the place to be searched. The personal property, again, let's include the person also. The search warrant must include or must specify the personal property to be searched or seized, the place to be searched, and the person to be searched or seized. There are three. There can be three. Personal property, to be searched or seized, or and the place to be searched and the person to be searched or seized. That must be specified in the search warrant. Take note that the rule, the section 2 of Article 3, the Bill of Rights, the right against unreasonable searches and seizures, is only a protection from government officials or government intrusions. Only for government intrusions. It does not extend to the acts committed by private individual and entities. That is in Cesbreno versus CA. Again, the section 2 of Article 3 of the Constitution, right against seizures, unreasonable seizures and searches, is only a protection from government intrusions, not from the acts committed by private individual. In addition, any evidence in violation or any evidence obtained in violation of Section 2, Article 3 shall be inadmissible, shall not be accepted as an evidence for any purpose in any proceeding. That is in Section 3, Article 3 of the Constitution. Again, any evidence obtained without the benefit of a warrant of arrest, without the benefit of a search warrant, such evidence obtained shall be inadmissible in court. Section 2. Court where application for such warrant shall be filed, any court within whose territorial jurisdiction a crime was committed. So again, any court within the jurisdiction of the court. Again, if the crime has been committed in Zamboanga City, so therefore apply for search warrant in the Zamboanga City, in the courts of Zamboanga City. For compelling reasons stated in the application, any court within the judicial region, the RTC, where the crime was committed, if the place of the commission of the crime is known, or any court within the judicial region where the warrant shall be enforced. However, if the criminal action has already been filed, the application shall only be made in the court where the criminal action is pending. So, if the case is already pending in Manila, so therefore, if the criminal case is pending in Manila, so therefore apply for search warrant also in the courts in Manila. Take note as a modification in applying for search warrant in cases involving heinous crimes, illegal gambling, dangerous drugs, and illegal possession of firearms. The officer or the PNP must apply in the executive judge and vice executive judges of the Regional Trial Court of Manila and Quezon City. So again, these are the agencies. If they will apply to the executive judge and vice executive judges of the regional trial courts in Manila and Quezon City, the issued search warrant shall be enforceable in the entire Philippines. So again, these are the agencies: PNP, NBI, PAOCTF, and REACT-TF, including PIDEA and Bureau of Customs. If these will apply for search warrant in the executive judge and vice executive judges of the regional trial courts of Manila and Quezon City, the search warrant shall be enforceable. shall be enforceable the entire Philippines. If cases involving heinous crimes, illegal gambling, dangerous drugs, and illegal possession of firearms. Section 3, personal property to be seized. It should be the subject of the offense. Stolen or embezzled and other proceeds, fruits of the offense, or used or intended to be used as the means of committing an offense. Properties may be subject to seize. Again, as an explanation, the personal property must be a subject of the offense. Example, if the crime was murder using a knife, so therefore one of the subject, the knife is the subject of the offense. It was used during the commission of crime. Stolen or embezzled and other proceeds, so the car, if there is carnapping, it should be the car is the property to be subject for seized. Used or intended to be used as the means of committing an offense, the knife. Ba? Take note that only personal properties described in search warrant may be seized. Yes, again, as a rule, only personal properties specified in the warrant of arrest, described in the warrant of arrest, must be seized or must be taken. All those not described in the search warrant, they should not be taken or they should not be seized. Again, only those personal property. Example, a knife with a specific length, with a specific size was described in the search warrant. That is the only thing that must be seized. No other things, only that, except in plain view doctrine. Again, as a general rule, only those personal properties described in the search warrant may be seized. Again, if a knife was described there with a specific size, with a specific length, that is only the knife, and that is the only thing to be seized, except in the plain view doctrine. Seizure of evidence in plain view. Plain view, nakita lang. In Alan Liwanag versus People, the requisites of plain view doctrine. Law enforcement officers in search of evidence have a prior justification. Example, conducting search warrant, search with warrant, for an intrusion or in a position from which they can view a particular area. So again, once a police officer, this is the first requisite. Law enforcement officers in search of the evidence have a prior justification in conducting search with warrant for an intrusion or in a position from which they can view a particular area. So either in their view, only in their view, when they are in a position and they can view it openly, very open, in their plane, it's very plain, you can see it from their position. Second is that the discovery of the evidence in plain view is inadvertent and it is immediately apparent to the officers that the item they observe may be evidence of a crime, a contraband, or is otherwise subject to seizure. So again, if officers will be making a search using rendering the search warrant, and then upon entering the house, they immediately see a knife or any contraband that can be used as an evidence against the accused. Only it's in their plain view. Or in the search incident to lawful arrest. Again, search incident to lawful arrest. There must be a lawful arrest first, then search. Example, if an officer will arrest a person using a warrant of arrest, so there will be handcuff. Then search the body for any weapon, for any sachet of drugs in his pocket or in his body, inside of his clothes. That is search incident to lawful arrest. There must be a lawful arrest first before a search incidents. There must be a warrant of arrest or flagrante delicto, hot pursuit, or escapee before a search incident. This is under Section 13 of Rule 126. A person lawfully arrested may be searched for dangerous weapons or anything which may have been used or constitute proof in the commission of an offense without a search warrant. So, as a general rule, only those personal properties described or specified in the search warrant must be seized, except when there is in plain view upon rendering or executing the warrant of arrest by a police officer, by rendering a search warrant by a police officer in the house, and then upon opening the house, he immediately saw a knife or a gun or any contraband or any personal property that can be used as a proof in the commission of an offense. And also, when there is lawful arrest first, then search incident or search incident to lawful arrest. There will be a lawful arrest even without the warrant of arrest, provided there is flagrante delicto, hot pursuit, or escapee from a penal institution. Upon handcuffing, then search for dangerous weapons in the body. Going back to the requisites for the issuance of search warrant by a judge, under Section 4, or these are the requisites for issuing search warrant. A search warrant shall not issue except upon probable cause in connection with specific offense to be determined personally by the judge after examination under oath or affirmation of the complainant and the witnesses he may produce, in particularly describing the place to be seized, to be searched, and the things to be seized, which may be anywhere in the Philippines. So, this Section 4 is coming, it's a portion from our Section 2 of Article 3. So, there can be no search warrant unless there will be probable cause. It must be concurring. There must be probable cause with or in probable cause in connection with a one specific offense. So, if the offense is murder, so only probable cause is there must be a probable cause that the crime of murder has been committed. Again, probable cause in connection with one specific offense to be determined personally by the judge. Then it should be after examination under oath or affirmation of the complainant and the witnesses he may produce, and particularly describing the place to be searched and things to be seized. So those are the requisites. Probable cause in connection with one specific offense, only one specific offense, only murder. If murder has been committed, the probable cause must be related to murder. Only murder, no other crimes or no other offense. And such probable cause must be personally determined by the judge after examination of the complainant or and witnesses that he may produce. Additionally, additional information when it comes with one specific offense, from the first requisite is that the probable cause in connection with one specific offense. This one specific offense is that the Constitution requires that a search warrant must be issued in connection with one specific offense. The single offense requirement is meant to prevent the issuance of scattershot warrant. Again, the single offense requirement is meant to prevent the issuance of scattershot warrant. The specific offense requirement reinforces the constitutional requirement that a search warrant should issue on the basis of probable cause, that is from Stonehill versus Diokno 1967. It is very important that the personal property described in the search warrant must be related to one specific offense. To one specific offense only. Because this one offense is a limitation. It limits the search warrant. It limits the judge. It limits the search warrant. It limits the judge in making search warrant for scattershot warrant. What do you mean by scattershot warrant? Seizing of personal property aimed to seize property those that are not anymore related to the offense. Again, scattershot warrant, it aims to seize. It aims to seize variety of objects, different objects that are not anymore focusing, that are not anymore pointing to one offense. Again, one offense, one search warrant. One offense, one search warrant. In order to prevent a scattershot warrant. In order to prevent seizing of variety or different property or object that will not point to one offense. That is, or not pointing to one offense, or that is already irrelevant to the aim of the search warrant. However, the rule, one specific offense to one search warrant is not a violative or not violated when search warrant covers several counts of a certain specific offenses. Again, as an exemption, the one search warrant equals one offense is not violated when search warrant covers several counts of a certain specific offense. That is in Columbia Pictures versus CA 1996. Example, 20 counts of falsification or 10 counts of estafa. So, certain specific offenses, that is falsification, but there are 20 counts of falsification. So therefore, your one search warrant will be equivalent to several counts of a certain specific offenses. So therefore, your search warrant must include personal property, those that are related to falsification, to the commission of falsification. Again, as a general rule, one search warrant, only those things that will be seized, that will only be seized, will be described in the search warrant. One search warrant is equivalent to one offense, except when there is several counts of a certain specific offenses. So different or variety of objects to be searched, provided they are pointing to falsification. This is an interesting case from People versus Pastrana, wherein one search warrant, one offense rule. Search warrant was issued for violation of Securities Regulation Code and for Estafa. Again, search warrant was issued for violation of Securities Regulation Code and for Estafa. So, two offense. The Supreme Court ruled that it is a scattershot warrant. So, there are two offenses already. As a general rule, one search warrant shall only include one offense. So therefore, the limitation is that if there are several counts of certain specific offenses. So if falsification, if there are 10 counts of falsification, that is the exemption to the one search, one offense. But if there are two offenses, such as violation of Securities Exchange Commission or violation of Securities Regulation Code and Estafa, that is already a scattershot warrant. Next, People versus Dichoso. The search warrant was issued for violation of RA 6425, the old law on Dangerous Drug Act, RA 6425, without specifying what provision of that law was violated. So again, in People versus Dichoso, the search warrant was issued for violating the RA 6425, the old rule on Comprehensive Dangerous Drugs Act, without specifying what provision of the law was violated. So the Supreme Court upheld, the Supreme Court ruled that the search warrant is valid. Only one offense. Even though it does not specify what provision of the law, but only one offense was stated in the search warrant, the Supreme Court said it's valid. There are many violations inside RA 6425, but Supreme Court ruled it is sufficiently valid.